Well, what is it?
It's backed up radio transmissions from 2014 that were, it was unknown to Jersey City that those existed until September 12th, I think it was September 17th of last week. September 17th or September 18th, the state became aware of the fact that there were CADs and radio transmissions backed up. Now these CADs and radio transmissions are, at the end of the day, absolutely unrelated to any of the issues in this case, nor were they ever asked for in discovery.
Well, if it's unrelated to this case, why was it turned over if it's not part of this case?
Simply because of the tone of this case, Judge. Simply because at some point there would probably be questions about whether any radio transmissions existed for that period of time, and to deal with this in advance of those questions to any of the state's witnesses, when the state got these radio transmissions and was aware that at some point the defense counsel would be making an issue as to the non-existence of any radio transmissions, the state, knowing that some radio transmissions from that period of time existed, turned them over in bulk with the idea that we would review them and obviously make a determination as to whether anything was even related to any potential issue in this case.
How much are we talking about? How many radio transmissions?
We're talking about hundreds of radio transmissions on separate files, Judge. The only reason they were preserved was because there were requests for these to be preserved and backed up onto discs.
How many discs?
5 discs.
There are 4. There are 4 discs.
Yes.
One disc is a compilation of all the radio transmissions and dispatches, but for the sake
for just 2014.
Not for the entire year, just for unrelated calls for emergencies and reports of a complaint, totally unrelated to this matter. They were saved because of Oprah requests for unrelated cases. It just happened to be that Ms. Manto, who is the supervisor of the dispatch for Jersey City, she had an epiphany, and she realized, oh, there may be some 2014 recordings due to Oprah requests or requests for to save.
Okay, so these radio transmissions deal with other matters.
Yes.
Other cases.
That's
so why
correct.
did you turn them over here? I don't understand. Outside of to confuse everybody.
No, Judge, this is not to confuse anybody or to create any issues, but to avoid this was going to come about as soon as one of the defense counsels questioned any one of the state's witnesses about whether they had any knowledge of any radio transmissions existing from this period of time. We would have been right here dealing with this issue.
Of course,
So,
no. Counsel, it can't just be any transmission existing for this period of time. It has to be related to the case.
of course it does, Judge.
But if these are unrelated to the case, I don't know why this whole issue came about.
Because I turned it over out of an abundance of caution.
So you just give them unrelated...
That's correct, Your Honor. That's exactly correct. I gave them unrelated radio transmissions and CADs. That's exactly correct. I gave them unrelated...
Why?
Because this question was going to come about just the same reason.
What's the question?
The question is, do any radio transmissions exist from 2014 during the period of an indictment? The answer is yes.
With regards to what? Of course, they probably exist for 2013, 2012, 2014, 2015, because you always have your CAD reports, okay? But that's not... You could object to that question because it's really unrelated to this case.
I could object.
Unless it's a radio transmission that exists as to these defendants.
Absolutely, Your Honor. And these are not radio transmissions that pertain in any way, shape, or form to these defendants or to the issues in this case. They were turned over because, quite frankly, Judge, I don't know that defense counsel was going to accept the state's representation to that. They have an opportunity to listen to them all. They have them all. It was turned over in an abundance of caution based strictly upon the type of arguments that Mr. Sciarra has made from the beginning of this case, alleging that there's something nefarious about the state's case, misrepresenting to the court that the state didn't ask for CSLI information when Mr. Sciarra knows exactly what came about in that. The state asked for it, the state was out of time on getting it, the state has to live with the fact that it doesn't have that. But Mr. Sciarra turns that into this idea that I didn't ask for them for some nefarious reason. I didn't ask for them because, as he said, they were going to exculpate his client. This is exactly why the state turned it over, Judge, because this was going to be an issue. And the state, quite frankly, was not about to rely on the fact that Your Honor was going to rule in favor of the state when I objected to a question about any unrelated transmissions as to whether it was relevant or not, Judge. I just didn't, quite frankly, I didn't want to take the chance. So I turned it over and let them listen to all these if they want. What happens is this, that it's now manufactured into this discovery violation. It's not a discovery violation. It's not even discovery, quite frankly, Judge. It was turned over in an abundance of caution.
Around the 2 o'clock hour on Friday, I submitted my correspondence to Your Honor. Let me talk about the prior strikes before we get to this one. Mr. Stoma did something that would never have survived before a jury. When I got up and asked Mr. Kakalewski about May 1st, on a date where my client worked, I had his voucher signed by Captain Askeles, as did my Eddie. My Eddie's indicted. My client is not. I indicated to Your Honor in an opening, I thought that that was a result of the fact that they had to weave in this Durango car accident and have some kind of motive to attach to my client to this case. Mr. Stoma got up and objected and said, we had telephone records that were in the case at the time that we no longer have. Now, had he done that in front of a jury, it would have been a mistrial. Probably, I would have asked for dismissal. It certainly would have been sanctionable because you don't tell a jury. By the way, you're not getting the full story because there was some evidentiary argument back and forth with regard to an issue and the judge suppressed it. So, wink, wink, nudge, nudge. But, as I said in my letter, there is some leeway because Your Honor must wear both hats. The fact finder on whatever goes into Your Honor's notebook on the facts, and then the judge on whatever goes into Your Honor's notebook with regard to legal argument and all the other stuff that goes back and forth on this. But that was something that was done in the case because, as we could see from their response file last night, they want to keep revisiting that issue. And I raised it and said, you know, on the first piece of this, they knew as early as January 2015 that there were allegations of no-show jobs in that motorcycle unit and never ordered that. And I said, had I had that, I wouldn't be sitting here right now. At least that's my contention because if we had better accurate information with regard to those phones, I'm confident my client would have been dismissed from this case a long time ago. Be it as it may, I knew I was not going to prevail upon the court for dismissal at that juncture, although, as I pointed out, the grand jury heard that information that no longer exists for the fact finder in this case. The prosecutor's office comes back to it as if to remind Your Honors, if you need to be reminded on a matter that we argued at length, that on 2 particular times, these wholly unreliable phone bills portend to show some kind of cell connection in the 3 o'clock hour outside of Jersey City. Be it as it may. My point with regard to that was, Judge, reasonable doubt, as my colleague Mr. Garrigan eloquently put this morning, is not just evidence, it's the absence of evidence. So, the fact that they didn't go pursue everything with regard to that certainly is something I would argue at closing if I get that far, but certainly something that could be addressed. Then we get to the Kakalowski testimony, seconded by Ms. Mahoney, resulting in your order, where the prosecutor himself was told DOT had issues and never pursued it. Your Honor made your ruling on that, but I do think that that is indicative of the fact that they don't want certain information, they don't want certain, they don't want to pursue certain things. They have their theory, they have their charge here in terms of what they're going to pursue and who they're going to pursue and how are they going to pursue them. I am not asking for a delay, Judge. That is not what I'm asking for. If Your Honor is going to deny the relief requested with regard to a dismissal, then I would ask Your Honor to forbid anybody who appears on any of these radio transmissions, anybody who appears on a radio transmission that the state has or could have gotten during that period of time be forbidden from trial with regard to any testimony about time and place. That's the second request. And if the state has investigated all this any cop there's 200 cops on there, if any of them got on the radio during any of these things, or could have gotten on the radio, they could have received that document, or those documents or that information by way of a request and gotten those transmissions, then I'd say, let's not have them come in here and tell that story. But I am asking, Your Honor, you know, without even getting into the other issues, because my client's involved with a conspiracy and there's allegations that there's a central protocol, they were looking for other discovery, and forgot to mention that too. But I'm asking that the matter be dismissed against my client.
In the first full paragraph, Mr. Sciarra identified the fact that there were transmissions that were saved on dates that coincide with the charge dates here. He pointed you to some. I just want the record to be clear that in the very next paragraph, there is also reference to additional transmissions that took place during DOT detail hours. Secondly, I'm not sure whether or not we've gotten all of the transmissions that are in the possession of the Jersey City Police Department. I know that we've gotten some discs that apparently had been saved by a representative of the Jersey City Police Department, but on page 3, Judge, I'd make reference to the first paragraph. It's the very first one, not the first full paragraph. About middle way down, the sentence begins, Ms. Manto also reported. If I could just read that. Ms. Manto also reported she found files saved on the network by the previous person responsible for the recording system. The undersigned believes that to be retired police officer Victor Coe. Now, from what I understand, there were transmissions that had been saved to disk. What I understand is that there were transmissions that had been saved to a desktop. Now, and I understand that those are the transmissions that have been turned over, but in Josward's report, we now have reference to a potential third location where these transmissions may or may not still exist. It indicates that they certainly may. And we don't even know whether or not we've gotten those yet. I, based upon an extremely cursory review, don't believe we got those. But I think it's incumbent upon the state to find out whether or not we have gotten those. That's the second point. The third point has to do with page 2 of Exhibit A, Judge. And that's in reference to Lieutenant Josward's efforts to obtain these transmissions that appear to go back to December. If you look at the first full paragraph, which is really in the middle of that page, he talks about how he had spoken to and emailed with Ms. Manto back in December of 2017. Now, as far as I know, and it may be my recollection is wrong, and I'm sure that if it is, that the prosecutor will correct it, but I don't believe that there is any report that's provided in discovery that talks about Josward's efforts in December of 2017 to get this information. We should have been informed as part of discovery as to what investigative steps Josward took to get this information, and the first we're finding out about it is now in this report in September of 2018, rather than back in December of 2017, or a report given shortly after the indictment that memorialized the steps that he had taken in December of 2013. And throughout that entire page, Josward makes reference to all these emails he has with Ms. Manto on this subject. We don't even have those. I submitted a discovery letter shortly after the indictment in this case that requested CAD reports and audio tapes. I understand that the state may have some issues with the exact wording of that, but I don't think it's really a hair that the state wants to split here. We were looking for the CAD reports and for audio tapes that dealt with and referenced the charges contained in the indictment. Josward doesn't even start looking for these things apparently until December of 2017. We don't even get a report on his efforts in that regard. So for all of those reasons and the reasons that have been advanced by counsel, Your Honor, we certainly request the relief that's been sought in all of the letters of the court.
Judge, I know you're going to give it over to Mr. Stone, but just ask to point this out. Mr. On page 3,
Yes, of Exhibit A.
of Exhibit A. All recorded, the last sentence of the paragraph, the third full one down, September 18, 2018, the last sentence says, all recordings and associated CAD tickets, if available, were reviewed, and no association between the parties involved, between the parties involved in this trial. I think there's a verb or two missing in there, or a prepositional phrase or something, if we go through the sentence and put the line across and everything else. But the point is, Judge, we continue to see the outsourcing of this investigation to an agency that two of these individuals are suing, are in an acrimonious back and forth with, and continue to see just blind reliance by the prosecutor's office. And that is the problem, is that Joshua is doing something in September of 2017, December, Joshua's around. That's the problem, is that there's this continued blind reliance upon a law enforcement agency which has, is being sued, and I would argue has a motive with regard to how it handles stuff. And the fact that the prosecutor just comes in and says, I got it now, so here you go, is not sufficient. They could have gone in, taken over this investigation, sent people down, done it all personally, and then all the overtures and all the assurances and everything that we're receiving from the prosecutor today might have some value to us. But as I said, and I was looking for it before, Judge, it was in my email, that I numbered number 5, September 20th. In the first paragraph, I put in parentheses, before anyone blows a gasket, I'm not accusing anyone in your office of withholding this new discovery, but the JCPD has some explaining to do, and your office's faith in them is by now manifestly problematic. So you can't, if I farmed out all my brief writing and found out that the cases were made up by someone I got to do my brief writing, I'd be standing there in a lot of trouble. I couldn't say, well, gee, I got Smith and I paid him a per diem rate to write a brief, so no harm, no foul. You put your name on it, you prosecute my client, you work to this day with an agency that has acrimony and difficulty with the co-defendants here, and you get stuck with the result. I'm asking you to dismiss the case against my client, Judge.
And in a case of this magnitude and of this scope, with this much information that was turned over at every turn, Judge, so one of the things I did want to point out, and I want to make sure Your Honor knows, this joint defense has known from the beginning how to ask for what they want. They have made specific requests for CAD information in the past. They have asked for, I point out to you as Exhibit D of my letter was Mr. Garrigan's first case-specific discovery request. Case-specific, not the stock discovery form request that was provided with Mr. Lytle during the notice of appearance for Ascalise, but a case-specific discovery request. And I direct your attention to what was marked as Exhibit D of my...
September 6th.
Yeah, you're not going to find anything in there with respect to a case-specific discovery request for any kind of broad information requesting CAD files or radio transmissions for any period of time. You will find, Judge, later on, and I didn't attach this, but this is a letter from Mr. Garrigan. Dated November 22nd, 2017. And again,
is that an exhibit that I have?
It's not, Judge. December 22nd, 2017. In light of the statement of Michael Maietti that you recently provided, it is requested you provide the following discovery at your earliest convenience. Any and all CAD records, dispatch records, event logs, responding unit logs, and the like for hazmat spill, motor vehicle accident hazard condition, and or traffic condition on June 12, 2014 between the hours of 12 a.m. and 12 p.m. in the area of Duncan Ave and Route 1 and 9 or the surrounding vicinity. Any and all CAD records, this is request 3, dispatch records, event logs, responding unit logs, and the like for motor vehicle accident, traffic condition, power outage, downed or non-functioning traffic light, and or damage to traffic light from a motor vehicle accident on or other cause on June 13, 2014, between the hours of 12 and 12, in the area of Route 109, Communiport, Virginia Ave, and Duncan Avenue City. These were specific requests that were complied with, Judge, because those CAD, the reports, the records do exist. They didn't even ask at that time whether audio transmissions existed because, again, Judge, at the time, the case was proceeding as if audio transmissions did not, the state did not secure audio transmissions. I understand that there is some consternation with respect to the fact that these things were discovered later on. I completely understand that, Judge. What I don't understand now is what the court's consideration of either of the remedies that were asked for. One, a dismissal of the indictment, or two, the idea that, and I think Your Honor caught this when Mr. Sierra, when you asked him to explain this, wait a minute, they're not going to be able to call a witness because he went on a radio at some point in 2014 on an unrelated matter? So the state, that in some way, shape, or form is going to be in some way, shape, or form relevant to his testimony, his or her testimony with respect to a particular day where they're being called to say, were you standing on a corner on one particular day? Yes, I was standing on a corner. Is that your pay voucher? They're not going to be permitted to testify because 2 months earlier they responded on a radio, and that radio transmission is now was preserved for another reason unrelated to this case or unrelated to the DOT. That's the remedy that Mr. Sciarra is asking for as a.
Well, he's asking for that remedy not based upon this, but in addition to how he couched it, strike one dealing with the CSL.
I do want to address.
Strike two with regards to the testimony of Mr. Katkalowski, in which it was discovered some DOT letters that I have now ordered him to appear, and that payments were made back by
Judge, I don't know if you.
And strike three, like this is what it's cumulative.
Yeah, Judge, and strike one and strike two only exist in Mr. Sciarra's mind, with respect to whether they have anything.
It's his argument.
Yeah, exactly, Judge, but that doesn't make it so. It doesn't make this strike three because Mr. Sciarra says this is strike three. I addressed strike one in my letter to Your Honor. He's saying that strike one was the state's failure to request CSLI information. One, we know that's not true. It's simply not true, and it's the tactic that Mr. Sciarra is using to confuse the issues in this court with respect to what the state has done. The state asked for CSLI information. The state was out of time to get the CSLI information. The state got CSLI information from a period of time subsequent to and we litigated that issue in front of Your Honor, and Your Honor made a ruling. And that ruling is a strike? How is that ruling a strike?
He is simply arguing on behalf of his client that within that 1 year period of time, your office has had this expert who didn't testify today with regards to...
What does that have to do with the...
Let me finish what he's arguing. He's arguing, listen, you have the CSLI information out there, and it was discoverable, and you could have obtained it within that 1 year period of time. And you've had this so-called expert that knew everything about telephone and technology. Therefore, he should have also known that there's a 1 year period where all of this becomes,
Judge.
I don't know.
How is it a strike?
But
how does that constitute a strike in this? How does that constitute a strike in this particular, in this area? How is the state's
that the
failure?
fact that you, representing the state, has failed to obtain this information, you knew it existed. You knew from the get-go it existed. But you decided not to even preserve it. And then when I find out during the hearing, all that's required to preserve this information is a simple letter that they supply to you. Not a motion. I'm like thinking maybe you should have done a motion, but a simple letter.
You are imputing to the state knowledge that there was a 1 year retention period.
The argument that is being made, you asked me how, and I'm explaining to you his argument. That they did this deliberately.
Sounds like you're accepting that as
maybe I am. I don't know, but it's just one
it's
thing
my job, then, Judge. It's certainly my job to make sure.
Counsel between you and me. No, I will give you an opportunity to argue your side of the facts, but I will not raise my voice as I am. Okay?
Yes, Your Honor.
Please. Yes, I give everyone, I think, an opportunity to be heard and to provide a record, so that you can appeal me at whatever decisions I make. You asked me, you don't understand his argument. I understand his argument. Am I buying it? Am I agreeing with it? I don't know. I've just been surprised with all of this last minute discovery. All these issues. I should be going through a witness. We should be proceeding as a trial, but instead, I have to stop and take the time and figure all this stuff out. So please, you asked me to explain his argument to you. I get his argument. That in and of itself, he's saying it's not just that, Judge, but then it's this we find out from Kakalewski, and then it's this, now with all this discovery and all these 14 discs.
May I move on to second point 2, Your Honor, Judge? Strike 2?
Just give me a moment, all right? Thank you. I'll be back. Thank you. All parties are here, and at the outset, let me just, to all counsel as well as the defendants, to apologize. The court has raised its voice at the previous argument, and so I apologize for that.
As do I.
Not to. Okay, and your apologies accepted. Thank you, prosecutor. And just frankly, I will give everybody an opportunity to create their record for, I haven't made a ruling on this, prosecutor. I really haven't. I understand the arguments that are being made before me, but I have not made a ruling, okay?
For the record, Judge, the state consented to a bench trial. The state has every faith that Your Honor will rule in an appropriate fashion with respect to Mr. Desquier's motion to dismiss, and the state accepts that. And I want to apologize for, I sometimes have the ability to evoke that response because I also have a tendency to raise my voice during the course of an argument, and it doesn't mean anything other than I really can't control that, and as much as I've tried for the 22 or 23 years that I've been doing this, it's just the way it is. Sometimes it works, oftentimes it doesn't. And so I apologize to the court, and I will do my level best to step back and articulate what the state's position is and move forward.
On these specific CAD reports, radio transmissions. Just listening or hearing, if the officer Donnelly has a statement, I presume, where under oath he says he would make radio transmissions, and there are no radio transmissions, or there are, I have no idea. But if they aren't, and under oath he says he did, that is a way of impeaching his testimony. The fact that they didn't find any radio transmissions, or what was provided to the defense today.
Judge.
I don't know. I don't have this discovery. I don't want this discovery until I need it, until it gets moved in at this juncture. But I do want to proceed with this trial. And this is what I'm going to do. It's 11:30. Hold your arguments until this afternoon, okay? Have your witness ready at 1:30. It gives me about an hour, and for whatever reason, I have a calendar this morning, and I don't know why they put a calendar on since I had this trial, and they've known about my trial date, but I know my team leader has been working to try to find other judges or see, and I see all these defendants, and they've been waiting patiently. So it gives me an hour to deal with that issue and that calendar. So I'll see everybody at 1:30 with the caveat that based upon all of this, and clearly based upon the application made by the defense, their motion for dismissal is denied at this juncture based upon the arguments of this discovery issue that's related in Mr. Sciarra's memo, September 21st, as well as Mr. Garrigan, I received your letter as well as to joining in this application, as well as Mr. Lytle in joining this application in your email to the court. So I'm denying your request at this juncture. I'll put my reasons more fully, but I will allow, my remedy is to allow the defendants to recall any of these witnesses if they need to during your case in chief at this point, or even during their summation. So I will remind all of your witnesses as they leave that they may be recalled and they will be under subpoena throughout this trial in case the defendants may have to be called as they're reviewing this discovery that was just turned over to them. That would be my remedy. the new discovery that was provided to counsel. I know as at least a remedy, I had allowed the defense to recall any of the state's witnesses and continue cross-examination of those witnesses, and then I would give them wide latitude with regards to that, since they were just recently made aware of new discovery material. That's one remedy. But I also wanted, and I think they know this, but just to be clear, that upon their review of this discovery and they believe that there's any exculpatory evidence, they may renew their application for dismissal, and upon doing so, please provide this court with a brief and particularly case law that would support their position. Okay. The court always looks to that with regards to case law to assist itself, and I know with this argument that was going on, it was somewhat last minute, but I still am firm on my decision with regards to respectfully denying the defense request at this time. But as they review the discovery, and if they come across anything that they believe is exculpatory, I would hear their arguments again.